So, good evening, all. I request everyone to place your right hand on your heart and request office to play ICI motto song.
य एष सुप्तेषु जाग्रति य एष सुप्तेषु जाग्रति कामं 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 कामपुरुषो पुरुषो निर्विमाणः निर्विमाणः तदेव शुक्रं तदेव शुक्रदब्रह्मा तदब्रह्मा तदेवामृतमुच्यते तस्मिन् लोकः शतः सर्वे तदूनात्यपि कश्चन एतद्वैता 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 एतद्वैता.
Good evening, all members, participants, and honorable chairman of largest region of the country, CA Saurabh Ajmera sir, who is the 75th chairman of WRC in its 75th year. Impactful, thoughtful, and empowering and believing in inclusiveness. That is what we can say for our chairman, CA Saurabh Ajmera ji, treasurer of the WRC, CA Rakesh Shah sir, faculty of the day, CA Dhruv Shah, and the coordinator, CA Yashvi Masruwala. Dear friends, as we are having and celebrating this 75th year, and innovative program under the leadership of our chairman is, I can say, custom for every day where we are having those programs organized for the benefit of the membership in this impactful year. I request now CA Saurabh Ajmera sir to give his words of wisdom to all of us. Thank you very much. Over to you, sir.
Thank you, Bishan Bhai, the dynamic secretary of WRC, who is always available for all the virtual and physical program. And when need of the WRC is there, we have again a very learned personality, treasurer of WRC, CA Rakesh Shah with us. And then we have faculty of this wonderful topic, basic and regulatory aspect of will and private trust as a tool for succession planning, CA Dhruv Shah with us. We have coordinator CA Yashvi Masroowala. And believe me, friends, this year at WRC, we are targeting to empower all our members through different programs on various topics. Our target is to empower all our members to accelerate our profession in a different way. And we want to create an impact on each and every stakeholder of WRC, as we are representing 50% of the population of the chartered accountant, and we are in the 75th year of our existence as WRC, and that is why we believe that we have more responsibility on our shoulder. And definitely to fulfill that, we are targeting to have all new innovative programs. We are driving an impact in terms of changing mindset also, where we are targeting our programs to focus on value addition rather than compliance, because we believe that compliance will be automated soon. But if we are targeting to have value addition in terms of litigation consulting, then definitely it will have a long future for our profession. And friends, we are also providing so many innovative programs in terms of providing training to all our members so that they can deliver in more efficient way, because we are known for the professional excellence. And friends, adaptability is one of the aspect for which we are trying so much, because if whatever we are organizing, if our members are participating, then only the object can be fulfilled. And that is why we always seek adaptability approach from all our members. Friends, this year, while organizing all the programs, we are targeting to have some networking also, some collaboration also. Because recently we had a largest ever cricket at WRC, where all the young professionals were playing. And first time ever we have come out with 45 plus age group separately, and women chartered accountant league also. And in that, more than 1200 professionals were playing together. They have enjoyed in terms of intuitive experience for the networking and enjoyment. Friends, believe me, the kind of energy on that day, I can feel it. It was really awesome to have such type of program at WRC in a more powerful way. And that is why we believe in the collaboration, and we have invited two more initiative on the approach of collaborative thing. One is CA Nexus, in which we are inviting data from the all small firms to have a collaboration with larger firms, and that is available in the initiative tab of WRC website. And I am very happy to say that more than 100 inquiries already we have received, in which definitely we are planning very soon a physical program. We will invite all the larger firms, those are open to take partnership, and we will have a physical programs in terms of again an interactive experience for all the smaller firms. Those are seeking partnership in large firm. Then we have one more initiative which is very important, that is WRC Corporate Setu, and in which we want to have more footprint from members in industry and businesses. And that is why we have come out with one day special program for all the industries, in which we are discussing about AI, how to manage decision biases and stress, how to be more communicative. Like that topics we are mentioning in 6-day training programs, which specifically we are providing to the members in industry and businesses, and we are inviting them to have a more footprint at WRC and ICI, because we generally feel that our members in industry are least connected. And that is why in this collaborative approach, we have come out with WRC Corporate Setu. Friends, we are also driving an impact where we are seeking that our members should transform in a way where country is heading, because we believe that our country is having humongous opportunities in terms of professional delivery, and that is why we are targeting to have a transformation through various initiatives at WRC in the life of professional. And we are seeking support from all the professional in terms of participation in the journey of our country. And that is why we have come out with Market Note Monday, in which we are discussing about the capital market and financial market. Then Sustainable Sunday, again a very important initiative, in which we believe that giving back to society is very important. And recently we had session on carbon credit. Similar way, we are doing some physical activity also for the social recognition, be it a blood donation camp, cleaning of sea, and there are so many other initiatives which we want to take under Sustainable Sunday. Then friends, as I am very fortunate that I am representing WRC in the 75th year as 75th chairperson of this largest legacy, and that is why we are seeking to have at least 75 new initiatives in this year, where we are all are inviting all our members to participate. So all other initiatives also are available on WRC website. And this program is also a greatest example of our innovative thinking, where we are discussing in a different way for succession planning. And again, a practical approach is there, where we are inviting all of them in such a great program. So my compliment to Vishan Bhai and Rakesh Bhai for organizing such a wonderful program. Over to you, Vishan Bhai. And there are so many programs lined up which you can see on WRC. One important program I want to highlight that we are doing first time ever in Geo other than regional conference, that is on GCC, Global Capability Center. Again, a great opportunity for all chartered accountant. Those are looking forward to have larger landscape. They can be participative at the GCC program, which we are doing on 16th May at Geo Convention Center. Over to you, Vishan Bhai.
Thank you very much, Chairman Sir. and kudos to your effort, because I seen and witnessed that cricket Mahakumbh last weekend, where more than 103 teams were playing, more than, I can say, 1,000 members to participation in the same. And it was a really great event, I can say mega event, so far as the networking and uh, playing is concerned. So thank you very much, Chairman sir. And as today we are having this unique program under your leadership, it is not I or Rakesh Bhai, it is only your vision who take us to a greater height. That is a program on basics and regulatory aspects of will and private trust as a tool for succession planning. Because I remember that it is also a tax planning tool as well. So in Sarabai, we were having those type of trust as well, family trust. But again, Dhruv Bhai will also highlight us how it's a better way for a succession planning. Now, taking this webinar ahead, I request Treasurer of the WIRC and learned person, CA Rakesh Shah sir, to give this introduction of the faculty. Over to you, Rakesh Bhai.
Thank you, Bishan Bhai, and good afternoon, friends. And congratulations, my young, dynamic, and enthusiastic chairman for recently concluded a large event, cricketing events for men as well as women's member of the WRC and ICI. Coming to today's subject, the will and the private trust. Uh, there is a saying in the life, two things are certain: taxes and death. And uh, we all plan for a long period on the taxes. We spend lots of time in planning our taxes, but many people ignore the will part, which is more again is very critical, since we the entire life we spent in accumulating the wealth, but we don't know after our death where this money and the wealth will go. So that's also equally important. And we have today a learned and eminent speaker, CA Dhruv Shah. So CA Dhruv is a
Thank you.
become become as well as CA and CS, and is a all India rank holder. He is having more than decade of experience in cross-border succession planning and FEMA and international taxation. He is a partner in Ambavat and Associate LLP, leading specialized international tax and succession practice. He is also frequent speaker at ICIA, BCS, CTC and taxation. He is also a faculty of ICI diploma in international taxation. He is having a previous experience with PwC Mumbai. He combined deep technical expertise with thought leadership in global tax matter. So welcome you, Dhruv Shah. Over to you,
Thank
Bisan
you.
Bhai.
Thank you very much, Rakesh Bhai. And as we are aware that we are having a program on Market on Monday, even Sustainable Sunday, we have announced one program this Sunday uh, for mindfulness through Bhagavad Gita. That lessons, I request everyone to join that program as well on this Sunday and Market on Monday, because this is a volatile currently the situation, and we must know how to deal with capital market. So again, thank you very much, Chairman sir, for having those unique initiatives for the membership at large. Now, taking it forward, I request CA Drusha to start his deliberation. Over to you, Dhruv.
Yeah. Thank you. Thank you, Bishan Bhai. Thanks to the entire team at WIRC for such innovative, all the programs and initiatives. Truly speaking, this being the 75th year and the kind of programs that WIRC is bringing up is really very exciting, and everyone is looking forward to it. And thanks a lot for inviting me to discuss such an interesting topic on succession planning. So yeah, with this, I think we'll move into the presentation. I'll just share my screen. Yeah. Is my presentation visible?
No, the whole
Not yet.
screen.
Okay,
So
just a minute. I
currently
think,
the
yeah, it's
documents.
coming up. Yeah, I think it's just coming up. Great. So while the time the presentation gets loaded, what I've done is, as per the discussion with the committee, what we'll do is I'll try and wind up my presentation somewhere between 6:30 to 6:45, so that we have good amount of time for all the Q&A sessions per se. And then we'll have sufficient time for other questions. So a request to all the participants, to the extent possible, please start putting down your queries during the session as part in the chat box or in the Q&A box, so that at the end we don't waste time in taking up questions. I'll just go one by one and I'll go through all the questions in the chat box and Q&A box, and I'll be happy to answer all of them. So good. I think my screen is my presentation is visible, but I think it's slightly slow. Yeah. Let me just change the network once. Yeah. So in the today's session, as far as the content is concerned, what we'll do is we'll be beginning with the introduction to succession planning. So here, what we'll do is we'll cover the basics of succession planning, which I think all of y'all would know. So I'll not spend much time behind that. The key slides in this particular content is going to be discussing around what are the various tools available for succession planning. So our today's topic is, though it is only focusing on will and private trust, but for succession planning, there are a lot of other variants and tools also available. So it is important to just have a brief introduction to all those tools. We'll discuss as part of the first point. And then what I thought is, whenever someone is approaching succession planning, what happens is we do not have a clear idea on the entire legal framework that is available and which all statute one has to refer to. So, as part of that particular point, what kind of legal statutes we have to cover to, that also I'll cover in the introduction session. Then we will move on to the core subject of our topic, which is will. And I'll be discussing the entire legal framework of will. Out of my experience, what I've observed is what are the preconditions of will, what contents we need to keep as part of all the wills. We'll discuss that. Then we'll move on to private family trust structure, which is the bigger part of our session. So in that, we'll be discussing about, first, it will be the introduction to private family trust. Then we will be moving on to the key constituents. In key constituents, understanding each of the constituents, like say settler, beneficiary, trustee, it becomes extremely important. So we'll do that discussion in detail. Then we'll come on to types of private trust. Okay, here I've kept a very interesting case study, which is practically also very much relevant because I've generally seen in my experience that people go wrong in doing the right classification of the trust. So this case study might help solve that particular issue in a complete way. Then we will go on to the trust deed and letter of wishes per se. Here, certain important aspects of what a trust deed is, and in drafting what points you need to take care of, we'll be doing that discussion. Then there is an interesting document, which is the letter of wishes. And in today's world, when we are doing succession planning, this holds a lot of importance So how that stands as far as the Indian context is concerned and how do you use that, we'll consider that. And finally, we will touch upon briefly the tax framework which governs the private trust part subject to the availability of time. So with this, let me directly jump into the topic. So first we begin with introduction to succession planning. Now, why are we actually discussing this particular topic of succession planning, and why even WIRC thought of keeping a session on this particular topic is, see, as of now, when we are standing today in the Indian context, succession planning is holding tremendous importance. Why? Because we all would be aware that in April 2023, India has now surpassed even China, and today we are the most populous country of the world. Now, that particular aspect, generally speaking, we used to all look at it in a negative way, but there is a very finer insight into that particular statistic as well. That out of the total number of population, the number of people who can get classified as, say, high net worth individuals or ultra high net worth individuals, where something of a family wealth of more than 10 million USD or somewhere more than 3 million USD it exists, and these kind of families are considered as high net worth and ultra high net worth families. Okay, so if we step back, say 4 or 5 years back, at that point of time, there are various global forums like, say, Forbes, Knight Frank, and there are other economic houses which keep on releasing a lot of reports and content on what is going to be the growth rate of each of the country, how is the wealth pertaining to each individual is going to grow in those countries. So all of those particular reports, the rate at which they were expecting the increase in the number of high net worth individuals in India, the actual speaking, post COVID, the number of high net worth individuals in India has dramatically increased. So we have surpassed all the projections that were made by the global community. And today, India has a very strong diaspora. India has a very strong pool of people who are actually can get classified as high net worth individual or an ultra high net worth individual. So to cater to this kind of wealth, cater to such strong business families, it's extremely important that such families plan their succession in the right possible way so that the wealth, the legacy can get passed on to the next generation in the best way. Yeah. So after looking at the statistics, just briefly let us talk about what is a succession planning. Okay. So typically speaking, succession planning might not be technically defined under any law. As per the industry parlance, what we look at it is that succession planning is actually a process. In this process, we thoroughly organize. Okay. We thoroughly organize. What are we supposed to organize is, say, for example, there is a patriarch in the family who is owning all the wealth. He was the entrepreneur who drove the family wealth to a certain extent. Now, what he has to do is, during his lifetime, he has to thoughtfully organize a system by which there is going to be a transfer of wealth, values, and legacy to the next generation. See, generally, when we talk about succession planning, our normal focus is always towards wealth, but succession planning has to be seen from a much wider aspect as well. That there has to be a legacy of the family, maybe brand of the family, which has to pass on to the next generation in a way that next generation should uphold that particular brand which has been created with a lot of hardship by the ancestors. A lot of emotional aspects also get covered as part of succession planning. So briefly speaking, if I were to summarize what is a succession planning, I would say that it is a process where I would thoughtfully meaning in a very planned way, I would organize the transfer of my wealth to the next generation. Yeah. Now comes an interesting question. In today's situation, why is succession planning needed? Okay, this is a very important objective. So, broadly speaking, we can divide the objective of succession planning into two parts. One could be emotional objectives, and there it could be financial objectives. Okay. Now, what could be the emotional objectives? So, what happens is that, see, succession planning, obviously, we'll be covering that in the subsequent slide, but just to give a brief introduction, in succession planning, one has to consider that I am the wealth owner. Now, I would have certain desires and certain wishes. So based on my desires, I would want the wealth to get passed on to the next generation. Okay. I would not want to, just leave my wealth unattended for. And if, say, because of any unfortunate moment, if I pass away, then I generally don't want my wealth to move on to the next generation, in a random manner or in a manner which is prescribed by the law, which might not always be as per my own wishes. Okay. So the main importance of succession planning, why we need to do is because every person would have certain desires and certain wish in his mind that how would I want to part my wealth with, to which family member, how much percentage I would want to go, I would want to give away, what kind of asset from my overall pool would I want to give to the next generation. Maybe there could be a wish that I have a lot of business assets, I have a lot of investments, and say I have a lot of immovable properties. I feel that maybe my eldest kid is the most dynamic person as far as business acumen is concerned, so I would want to give the business assets to that particular kid. If, say, there is a kid who is very good in arts, okay, he doesn't have good business acumen, but he's extremely good in arts, and he might want to go ahead in his life and explore arts. So he would be the one who would not be very actively involved in the business. So say maybe for his security, I leave my financial securities and financial wealth for him. There could be someone whom I would prefer that my immovable properties should go. So I could have different kind of desires because I know how my family composition is. So what happens is that for certain religions, say for example, like the Sharia law, which applies to Muslim families. So Sharia law is a very different law, which does not allow you to go ahead with succession planning as per your own wish. Sharia law is something where they feel that, as per law, there should be a certain level of succession. Everyone should respect that succession, and nothing should go to the next generation as per your own wishes. So, in that cases, maybe to some extent, your desires and wish are not fulfilled. But still, if you want to do something based on your own desires and wish, you can use certain tools of succession planning, be a bit more proactive, and then go ahead with your succession plan so that your desires and wishes are respected by law and they are carried out as per your own desires. Another very important succession planning thing is, which we are seeing in today's situation, is a possibility to avoid conflicts in the family. Now, what this means is we are all seeing in front of us, there have been such big family houses where the succession was not drafted in a very well way. And it led to a lot of disputes in the next generation where partitions had to happen, business assets, family assets had to get divided. So it can get a lot more messy. So during the lifetime, when the business owner is alive, if he does a very strong succession plan by which, his wishes and everything is framed in such a way that possible conflicts after his death in the family can be avoided, then that is also one strong emotional objective which one has to consider. Yeah. Then moving on to the financial objectives. Succession planning also has strong financial objectives. First of all, it would be ring fencing of assets. This is a very, very important tool, especially in today's time, because now we are standing in a position where a lot of our actions can lead to certain disputes or certain litigations arising in our personal name. Okay. If, say, for example, something goes south, it is not leading to the way that we wanted it to be. And those kind of disputes are leading to a very hefty liability in my individual name. Then I would at least want that my assets, which I have created with a strong, hard work throughout my entire life, which I created actually for my family and the next generation, that pool of assets should be ring fenced, and it should not be attached to take away any liabilities or any kind of recoveries for the personal liabilities that arise. Many a times ring fencing is also required for situations which are where I am not the active person because of which the liabilities have arisen. Let's take a very simple example. We would all have a lot of our clients who are high net worth individuals. We would also know that those individuals, these days there is a very strong trend of HNI families investing into high potential unlisted companies, right? Like startups. So they feel like now we have a sufficient family pool. We would want to invest into startups so that if there is any successful startup, then our fortunes can get multiplied. Okay. And there is also an interesting thing, or an exciting thing which is going on in this fraternity is that by making investment in that startup, they would also want to take a board seat on that startup, because that is also these days a kind of a, I would say, a glamour factor, that I am on the board seat of so and so startup. Now, what happens is, though this particular gentleman or a woman would only be taking a independent director boardship per se. But what happens that even if you are just an independent director, okay, still, if the underlying company is doing any non-compliance in certain laws, then those laws are drafted in such a strict manner that even notices are being sent to the independent directors as well. In many cases, even the independent directors have been made to pay certain liabilities. So, here nothing was in your control. You just took the board seat because you made investment in a company. But now even you have to discharge certain liabilities. So you would always want your assets to be ring fenced so that none of your hard earned money or assets are getting drained because of unwanted litigations. So that's a very, very important financial objective which we have to achieve. And last is protection from estate duty. Now, this is not yet introduced in India, but we are all aware that a lot of bankers, financial institutions, and wealth management houses are strongly predicting that the way in which the high net worth individual count is increasing in India, when they study the global laws, even I have done a detailed study of the global estate duty laws, where in most of the countries, the time when these laws were introduced, India is about to be very close to that particular time, because we are seeing a massive rise in the number of high net worth individuals. So there are chances that estate duty would get reintroduced in India. Just for the benefit of the participants, as to what an estate duty means, is estate duty per se means that if, say, at any today, say it's 30th April 2026, if God forbid something has to happen to me and I am no more, so what happens is that if estate duty would have been valid and applicable in India, then as on 30th April 2026, which is the date on which I have died, all my assets would be computed, would be listed down. All the assets which are in my personal name, those would be listed down. Market value of each of those assets would be computed, and the entire market value total of all my assets is going to be treated as my estate. That is the definition of estate, which is my entire asset pool as per market value, less liabilities, if any, that is my estate, and a certain percentage of this estate would be taken over by the government. Now, this particular thing is extremely important because estate duty in many countries is as high as 40%. In certain state of US, the total estate duty cumulates to as high as 40%. Now, just imagine, we are not talking about the rate of tax on your income. We are talking about a rate of duty that is computed on the fair market value of your entire estate, and that entire 40% moves to the government, and the next generation would only receive 60%. So today, HNIs are lucky in India that estate duty has not yet been introduced. So if a good if sufficient action is taken and the right action is taken in a proactive way, then they would be able to protect their estate from estate duty to a certain extent. Yeah. So these are like the broad objectives. So whenever you are evaluating any tool for succession planning, you should evaluate whether any of these objectives are getting met or no. Yeah. Now, this is just a theoretical side on how succession planning was used to happen in ancient India. But I think, considering the time at hand, I'll skip this particular slide. We'll come back to it if later on we get sufficient time, or if any one of you is interested, you can just put in a Q&A for this particular point. I'll cover that and at that time. Yeah. Now, this is an important slide on how do you navigate the legal landscape of succession planning so that you can offer the right advice to your clients. Okay, because many a times I've observed that many professionals struggle to even have the broad index of what are the laws that we have to use or refer to design the right succession plan for a client. So this particular slide will act quite handy for you guys. First is, we have to refer to the personal laws. What does personal law mean? Is personal law means the law that applies to me based on my religion, faith, or certain kind of a belief. Okay, what are the common personal laws in India? It is the Hindu Succession Act, which applies to all the Hindus, Indian Succession Act. Then there is a Sharia law. Sharia law usually applies to Muslims per se, and there are many other laws. So based on your religion, a certain personal law would apply to you. Now, the beauty of personal law is this is a by default applicability. Okay, you cannot say that this particular law, say if I am a Hindu, I cannot say that Hindu Succession Act will not apply to me. Okay, that applies to me by default per se. I have to appreciate the provisions. There are ways to manage the provisions if you have to do a certain kind of a succession plan, but applicability is by default. Yeah, how does this apply? So there are preliminary factors based on which this law apply. How do you decide that is? First is it is by birth. Okay, the religion in which you take birth by default defines which personal law is going to apply to you. Okay, so this is a natural factor. Then what happens is during your lifetime, if you marry someone who is not of the same religion as your birth religion, okay, I would repeat, you marry someone who is not of the same religion as your own birth religion, then again there is a event wherein there are chances that your personal law might change. Okay. Then also happens because of religious affiliations. Like India is a secular country, we have a right that by our choice we can change our religion. Okay, so if I do such kind of a thing and if I affiliate myself with a religion that I can reflect to or I can associate with, and I change to that particular religion, then again my personal law changes. Okay, so based on this event, my your the personal law applies to me, but again the point is this is a by default applicability. So whenever you are designing any kind of succession plan for your client, please decide which is the personal law that is applicable to him. That should be the first step, and then you move forward. Yeah, after you have decided the personal law, then your journey moves towards the statutory laws. Which are the statutory laws that we need to consider? Is there is a big list. I have just listed down a few of them. One is income tax, which we are all aware of. We'll be discussing that today as well. FEMA also is extremely important these days because I think most of the time if you'll see an HNI family in your network, I would strongly, the statistics would say that more than 75% of the families would have a cross-border exposure. What do I mean by cross-border exposure? Is either the family would have certain assets which are situated in other countries or in more than one country, or the family composition is such that there are certain members who are based out of in India, and there are certain members who are based out of in other countries. Yeah. So the statutory laws, which so FEMA is a law which applies when there is a cross-border angle. Either your assets are in more than one country or your family is in more than one country. So a very important law to be appreciated when we are doing succession planning, especially in the cross-border space. Then comes the question of stamp duty. Very important law. Many a times it is missed, and it is extremely important. Why? Because see, in succession planning, what you're predominantly dealing with is transfer of property from one generation to another. And this transfer of property would generally be backed by a deed or by an instrument of transfer. So, stamp duty clearly applies on such deed or instrument of transfer per se. If by chance you do not pay the right amount of stamp duty while executing this particular deed of transfer or the document of your succession plan, and God forbid, if something happens in the family whereby your entire succession plan is attracted into a court and there are certain disputes. So the Indian Stamp Act clearly says that if there is a document on which right amount of stamp duty was not paid, then such a document cannot be admitted as an evidence in the court. Okay. This becomes a very, very important point. I have seen many families who have been struggling with this particular part because there was a family arrangement, a proper documented family settlement arrangement, or a trust deed, or a deed of transfer which was executed. But since it was within family, they missed paying the right amount of stamp duty. And today there are disputes, and this particular document is not getting admitted in the courts because of the provision of the Indian Stamp Act. So stamp duty is a very important law to be considered. Then comes the Transfer of Property Act, often ignored, but a very important law. whenever there is a transfer of property that has to happen, one has to refer to the Transfer of Property Act. There are a lot of sections in the Transfer of Property Act which you will be surprised that, yeah, this particular law exists and we were not aware of. Very important act. Then we come to the Registration Act. Registration Act governs what kind of documents are mandatorily to be registered with the registrar and what documents are optionally to be registered. So there are certain documents which we use in succession planning which are mandatorily to be registered. And if you miss registering that, again you are defying our law, and then that document might not have its right legal eligibility or validity. So again, an important law to be referred to. Yeah. Now, how these particular laws apply. The way we discuss for personal laws, that personal laws applied based on birth, marriage, and religious affiliation. In the same way, how do statutory laws apply? So the triggering event for a statutory laws is generally your citizenship. Based on your citizenship, your nexus arises and the law applies. It also applies based on your residential status. Like for income tax and SEBA, your residential status is extremely important. Then there is the concept of domicile. Domicile is very different than residential status. Altogether, a different topic in itself. Like I can talk for hours and hours only on the subject of domicile. It's such a subject, but you can consider it as like residential status. It's linked with your physical state. Domicile is linked with a higher emotional objectives. Yeah. So based on your domicile, it happens. It also happens based on the situs or location of the asset. Situs means the location of your assets, where your assets are, which you plan to pass on to the next generation. So these are the trigger points based on which the statutory laws apply. Yeah. Now coming to an interesting slide where we are discussing common tools for succession planning. Yeah. So the first and foremost tool is the gift deed. Many people say, yeah, gift deed is not a succession planning tool, which is a wrong concept. See, succession planning is a beautiful thing. Uh, you have certain assets within the family, you are transitioning the assets to someone else. Something that you do during your lifetime by just directly transferring to the asset to the next generation is nothing but a gift. That is also actually part of the succession plan. So, whenever for our clients we design a succession plan, we always tell them that don't let everything pass on to the next generation only after your death. Something which you are 100% certain has to move right now, do it in a clean way. Just make a gift deed and pass it on to the next generation. So gift deed is an important tool for succession planning. Then in the Indian context, HUF, we all know, has also been a good tool of succession planning. HUF comes from the ancient law, from the Mitakshara law, which, is part of this particular slide. Yeah, for the Mitakshara law. We'll discuss that in the end. So in traditional India, there was Mitakshara law where they felt that everything in the owned by the family generally belongs to the family at large. So currently also, if there is a then what is the third tool that is commonly used for succession planning? It is actually a will. Yeah, we will be discussing will at length today, so let me not focus on that right now. We'll move to that when we come over there. Then it's the trust, even private trust we are going to be discussing in detail today. We'll discuss at that time. Then there is an important thing called as family arrangement and family constitution, or a family settlement arrangement. This is nowhere legally defined under law, but there are certain legal precedences that support this kind of an arrangement, where what happens is that the entire family comes together. They prepare a agreement which is called as a family charter agreement or a family settlement agreement, and in that agreement everything is listed as to how the family assets would be distributed, managed, or owned by the members. And this agreement holds legal validity because of certain legal precedences, and that becomes like a family charter and guides and governs the entire family succession. And then comes the family office setup, where say it's for very huge promoter families or high net worth individual families where they have lot of assets. So they would actually want to set up a family office which would have multiple vehicles like say firms, LLPs, companies, multiple trusts, HUF, a lot of entities put together in a collective way is called as a family office. These are the common tools that we evaluate for succession planning. Now we move to the section 2 of our discussion, which is actually the discussion around will. First, a brief introduction to a will. What actually is a will? Okay. First of all, will. So let me go to the next slide first, and then we'll come back over here. So definition of will is available under the Indian Succession Act. Okay. The Indian Succession Act, Section 2, subsection H, defines the term will. How is it defined? It is a legal declaration of the intention of the testator with respect to his property, which he desires to be carried into effect after his death. A very simple definition, and very easy to understand as well. Here, what it says is, it is first of all a legal declaration. Okay, please focus on this word. The law gives will, which can be drafted in a very lucid way, need not necessarily be on a stamped paper, need not necessarily be drafted by a lawyer, on a simple black and white paper. If you are writing anything, then legal declaration, this particular section gives it a power of legal declaration. Yeah, it gives the power of a legal declaration, this particular section. Now, what does this legal declaration contain? It contains, so it is a declaration of the intention of the testator. The testator is intending to do something. What is he intending to do is, he has certain property. He wishes to lay down his desires. Okay, desires is a very, very beautiful word. This gives an emotional angle to a legal document. So this is a legal document where my emotions, my desires are put on paper, and this particular section 2, subsection X, gives my desires the form of a legal declaration. And it is carried into effect only after my death. This is how the definition of will is covered under section 2H. Okay. Now we break it up into a couple of parts. First of all, it is effective only at death. Okay. Many people say that I have a very strong succession plan because I have written a will and I have a live plan. It is in front of my eyes. Please consider this to be a wrong notion. Your will, until the moment you die, is only a piece of paper. It has no legal validity. Only when you die is when the will is going to be received by the executor and it will come into action. So say, for example, while drafting the will, there are certain prerequisites of drafting of the will, which we'll be discussing in due course. So there are certain prerequisites of drafting of the will. Anything from that you missed, okay, no one is going to come and tell you that your will is not valid. It would remain valid. You would be under that notion that I have done my succession plan, my will is ready. At death, if something comes up saying that your will was void ab initio because certain basic provisions of the Indian Succession Act were not followed, then your will not take into effect. So whether your will is valid or not valid, that will also be tested only after your death, and its effect will also only be carried out after your death. So what does this implies? Until your death, you will have full control of the asset. So complete ownership and control of your asset remains with the person who creates the will. So anything that you plan to bequeath by writing a will does not get ring fenced. Why there is no ring fenced? Because you are yourself owning the property per se. You have written a will where the ownership will only transfer after your death. So before your death, if any kind of liability arises on you, there is no ring fencing to this particular asset. No? Personal law is a precondition. Okay, will is something where you need permission from your personal law to draft. Okay, not all religions and not all personal laws freely give you the permission to write a will. So say, for example, Hindu Succession Act grants all Hindus the right to write a will. What it means is, under the Hindu Succession Act, there is a defined mechanism that law prescribes or law is guiding you that your wealth should move to the next generation in so and so manner. Okay, they define the classes of heirs and they suggest that it should move to the next generation in so and so manner. But they also say that this is only a guiding factor. If you feel in your own sanity, in your own wisdom, as per your own desires, that your wealth should move to the next generation or to someone not in the way as it is prescribed in the Hindu Succession Act, but as per your own whims and fancies or on based on your desires, then you have a free power to write a valid will which will override the mechanism that has been given under the Hindu Succession Act. So Hindu Succession Act permits you to write a will. So I have the permission from the Hindu Succession Act to write a will. But there are certain laws, like say the Sharia law, which applies to all the Mohammedans, all the Muslims. Under the Sharia law, the law is very strict. Law says that you cannot write a will based on your own desires. All your estate, all your assets will move to the next generation strictly as per the process which has been written under the Sharia law. Yeah. So here, if you are a Muslim, if you are governed by the Sharia law, then you do not have the permission to write a will. Okay. So before, it's a very important thing to check that this is a precondition. Whenever a client comes to you, please check whether the personal law is granting permission to your client to write a will or no. If it is granting permission, only then please go ahead with the drafting of the will. Yeah. Then comes the point of infinitely revocable. Okay, this is again a beautiful point. Many people ask me, what if say I write a will today and in future I want to change that? If your personal law is permitting you to write a will, then generally speaking, you have infinite number of times to change the will. Every day of your life also you can write a new will. Whichever will would have the latest point of time, whichever will is going to be your last will, that particular will hold the legal effect and that will take it for and that would apply and that would be your last will. So you can amend, you can revoke or entirely rewrite any number of times during your lifetime your will. Only the last will remain the final one. Yeah? So this was a brief introduction to will. Now, certain recent developments in the will which are important to know. First is Section 2, subsection H, which we have already discussed. I think this is all. Let me just slightly zoom in for you all. Yeah. Section 2, subsection H, we have already discussed, which defines the will. Another beautiful section of Indian Succession Act is Section 76, which says that any errors in name or description do not invalid if the intention is clear. See, again, a very beautiful document. The moment we see that it's a legal declaration, what our mind states is that this is like an agreement. Now we have to read the agreement through the lawyer's lens per se. Every comma, every full stop, every word has to now be referred to as part of an agreement. That is not the case. Okay. Section 76 is a very beautiful document, which again reminds you that the intention of the settler is of foremost importance. Okay. The intention will always override. So if someone is writing a will who doesn't have very good vocabulary strength or he's not very good at writing, still in whatever language he wants to write, if he has been able to put forth his intention in the right way, then if say there are basic errors like spelling mistakes, certain errors in description of the asset, certain errors in names, everything will get overridden. If the intention is clear, then the Section 76 of the Indian Succession Act upholds that, and that would still be treated as a valid will. Now, certain recent interesting amendments which we all have to keep in mind is one is about the probate. Okay. So we all know that recently in December 2025, there was a lot of hoo-ha around a statement that probate is no more valid, probate is now a history and everything. But in a very humble way, I would like to make my submission is that we have interpreted that amendment in a very wrong way. Okay. Let me tell you the right position which is there today. So, first of all, what is a probate? For the benefit of all, probate is a process where what happens is that you have a will, you have passed away. Now, before your will can be acted upon, before the executor can start distributing your assets, the law mandated that you have to take the will to your court and the court will decide whether this is the last and genuine will of the person who has died or no. Okay, let me reiterate over here what the court is deciding. The court is only deciding whether this is the last and genuine will of the person who has died or no. The court is not going into the contents of the will to say that whether the transfer of wealth has happened in the right way or no. That is not the court's prerogative. That is as per the testator's desire. Testator meaning the person who wrote the will and passed away. It will go ahead with that desire. But the court will say that this is the last and genuine will, so that later on no one can come with another document stating that this is the right will and the old will which you allowed was the wrong one. So that is not permissible. So probate was only a process available to establish the genuineness and the later in date test for the will per se. Now, in all the princely states, which were like cities like say Kolkata, Mumbai, and stuff like that, in those cities, if there was an immovable property, then Section 213 of the Indian Succession Act mandated that your will has to be probated before the property can pass on to the next generation. Okay. That was the law before December 2025. Now, in December 2025, what happened? So in December 2025, Parliament passed an act called the Repealing and Amending Act 2025, in which they said that Section 213 of the Indian Succession Act will no longer apply. They eliminated the section. Okay. So, does it mean that the probate process got eliminated? The answer is clear no. Probate process has been in the Indian Succession Act since lot of years. There was Section 213, which only said that in certain cases, probate is mandatory. So, only that limited section has been eliminated. So, as on today, does the probate process exist? Yes. What is the position? Now, probate is optional across the country, across all the assets. Okay. So, practically speaking, still for all high value of assets, there are chances that the investee companies or the property owners would ask for a probate, because if the without the probate, based on the action of the will, certain assets are transferred, then is a lot of nuisance because of which all the parties get attracted towards that. Uh, Sorry, just a minute. I'm receiving a call. Just need to check if it is from the person. No, yeah. My voice and everything is clear. I think it's not from the committee. Someone from the committee can.
Yes, it's clear.
Okay, great, perfect. Yeah, so I was on the probate process. So today it's optional. It is existing for high value stakes. Please be ready. You will still get requirements of probates. Yeah. Then coming to a very important act, which is a Special Marriages Act. One more important thing is, let's say an example of Sharia law. If someone to whom Sharia law is applicable, if say that person is married to someone else who is not a Muslim and not governed by Sharia law, so there are people from two different religion, they have an option to not register their marriage based on their personal laws. They have the option to get their marriages registered under the Special Marriages Act. If your marriage is registered under the Special Marriages Act, then Indian Succession Act states a provision which states that if your marriage was registered under the Special Marriages Act, then now you get the right to write a will. Yeah. So if say you have any clients whose personal law does not allow them to write a will and they are yet to get married, so there is a good option available that if it is possible, obviously personal aspects would always override. If they are willing and they get their marriages registered under a Special Marriages Act, then there is still an option available that they can come out of their personal law and now they can draft their will as per their own wishes. Yeah. Certain other interesting developments where a will is important is co-parsonary interest. Okay, this has always been a point of debate. Co-parsonary interest, what it means is there is an HUF. All the co-parsoners of the HUF own a co-parsonary interest into the HUF. But till the time the HUF is not partitioned, this particular co-parsonary interest is into an undivided property. Until the partition, all the properties of HUF are treated as undivided property. Okay. So in 2005, the Hindu Succession Act was amended, where a very good provision was brought in is that the daughters would now have co-parcenary right even in undivided property. Okay. And as per that amendment, daughters, even though they get married, they still have the right in the co-parcenary property of their parents per se, HUF of their on their parent side per se. So a very important amendment. And then there was an important ruling in the month of in the year of 2019. It's a Supreme Court ruling in the case of Radha Amma and others, where what they stated is undivided co-parcenary interest. Please pay special attention on this point. Let me just highlight it as well. I'm talking about undivided co-parcenary interest. Okay. Undivided co-parcenary interest is not your individual asset because it's still undivided. But undivided asset, as per this ruling, can also be bequeathed through a will. Okay, very, very important point. Whenever we have been drafting wills, generally when we ask our clients to please submit their list of assets, they usually forget to mention that they are co-parceners in so and so HUFs of their parents. Okay, based on this ruling, what it says is that when the person is writing his will, if that person is a co-parcener in any of the HUF, please mention as part of your will that my undivided co-parcenary interest in so and so HUF should be bequeathed to the next generation in so and so manner. So even though it is undivided, even though it is not quantified, but for the will purposes, it becomes extremely important and should be made part of your will. Yeah. Next, coming to the point of video will. Okay, this is something which in this days is going to be quite active. What would video will actually mean is, in a video will per se, uh, it is something like taking a selfie video. Okay, what do you do in a will? You generally write will on your paper on a with pen and paper. Someone would prefer that, yeah, rather than writing it on pen and paper, what if I just record a video, and in the video I just put up my desires. I dictate that what are my assets and how that should be concerned. Today's time, with the technology being so much at our in our palms, this could be a possibility. So whether video will is valid or no, we get a lot of queries. So let me clarify that position. Indian Succession Act has not yet been amended to this effect. So there is no express permission allowed under the Indian Succession Act for a video will. Okay. But there are certain recent developments, not exactly on a will, but in many cases, the courts have started admitting videos as valid evidences, citing references to the information technology law. Obviously, the case might have not yet been come up to the courts for testing its validity, so it is difficult to take the stand today. But I feel that going forward, this would be brought into the law, because video will is actually a very good way to write your will. A lot of things can get overridden, like say coercion, whether you were under coercion, whether you were of sane mind or no. All those points automatically get overridden, because when you are saying something on your video, a lot of things can appear in an apparent way. Yeah. So as of now, what my recommendation will be for your clients, what you should do is write a will on a paper, and then do one more thing: record a video where the person is reading out the entire will. Okay, and have the witnesses also be present as part of the video. All the three people, the testator and the two witnesses, all of them sign the will as part of that video, and also keep this video as a good reference point. So what would happen is, now in future, if someone has to say that your witnesses did not sign in the right way, someone has to contest your will that maybe you were not in the right mindset, you were not healthy at that point of time, all those arguments will get overridden, because this video will act as a very strong proof. So write a will, read it out on a video, let the witnesses and you guys all sign as part of that video. A very good way to execute a will. Yeah. Then we get a lot of question around what is a joint will. See, basically joint will is not a very novel concept, or not which the law suggests. It's basically, say it's a family, husband and wife. Most of the assets they share equally. So what they say is that, rather than having two separate wills, if our desire is also similar, let us put down one common will, where we list down all the assets that the husband is owning, all the assets that the wife is owning, and whatever they agree on how it should move to the next generation, they put it as part of the same document. An important point over here to be kept in mind is, Okay, this need not necessarily be that all the assets are bequeathed in the same proportion. Husband can capture his different desires, wife can capture her different desires also, and in one single document it gets covered. Yeah. Last point, gist of the court cases where will is challenged. What happens is, these are the three key tests, which is my summary of reading multiple laws. Is what were the points where a lot of arguments or discussions came up on will and where the litigation existed. So generally the court tries to prove these three things. First, whether the testator himself has signed the will or no. So this is where the witnesses come into importance, whether the testator himself signed the document or no. This is a big test which the courts wants to verify. Next is, did he understand the nature and effect of the dispositions? Okay, was he in a sane mind, and was he not toxicated? Was he not under a frame of mind where his conscious mind was not active? So did he actually understand what is going to be the nature and effect of what was written in the document? This is what the courts want to verify. And last is, say for example, he was in the sane mind. He was told that this is the document what was written over there, and he signs it. But in the document, actually something else is written. So did the person sign it knowing that whatever is the his desires is exactly the same thing that is captured on the document? So these are generally the three tests which the courts wish to verify. Once they get a positive answer for this, the will gets upheld. Yeah. Key ingredients of will. Uh, First of all, name of the executor should be mentioned and his succession should be mentioned. Executor is a very important role which plays in the will. But what I generally have observed is people only name one executor. Now there could be a situation where, because of an unfortunate event, the executor passes away before the person who was supposed to die. So now when I am dead and my will is brought up, it names an executor who has predeceased me. So now that executor is not there, so the action of will becomes very difficult. You have to go to the court, get a letter of administration. A lot of complexities increases. So it is better that even for executor, you have a succession as well. That if this person is not existing, then so and so person will act as executor. If he is also not there, then so and so person. Give a hierarchy. Yeah. It has to be signed by at least two witnesses. There has to be an express statement mentioning that all your prior wills and codicils have to be done away with. And this particular will be my last statement. This is a very, very important statement. Okay. Even though your will is later in time, but say, for example, you forget to mention that this particular will overrides all the previous will, and now in this will, say the language is ambiguous. So there will always be a situation where two wills can get contended, because someone can say that my latest will is not covering the aspect that was covered in the earlier will. So it creates a lot of confusion. Please mention an express statement to revoke all the wills. Yeah. If it is an old testator, obtain a medical certificate of your good health, attach that as an annexure. If there are others, please mention a declaration that you are writing the will in your own sound mind and you are healthy. Okay. Write your religion as part of the will. Very, very important point. People obviously many a times miss writing this particular part. I strongly suggest that write your religion and which succession law applies as part of the will. Then comes the situation of identification of all parties. Okay. Uh, Identify all the parties, which is the executor, all your legal heirs, and everything. You just identify per se and put them down as part of the will. Now, in identification, what are the important points is you have to put down your mobile number, you have to write your email ID, you have to write your citizenship, your PAN, Aadhaar, and address. Now, why so many things are required is because, see, today we like say 50 years down the line, entire family and everyone. Sorry, I think, yeah. Everyone used to stay closely. Okay, so if you write a will and something has to go to the next generation, everyone was staying nearby and they could all, easily identify that all the parties could be easily identified, and we could easily reach out to them as well, per se. But now these days we are in a globally mobile world. Okay. You never know your next generation executor who is going to be staying where. So there could be a situation where now you are no more. your will is actually getting executed, but you are not able to actually identify who and where the beneficiaries are per se. I think my PPT is lagging a bit. Just ignore the marks for some time. I think it should catch up. You can just listen to me. So, identification of all the parties is extremely important. Mention their mobile number, mention their email ID. See, mobile numbers also keep on changing as and when people move from one place to another. Email IDs are generally something which people would continue throughout their life. Mention their email ID also. So, if need be, you can reach out to them via email. The executor can reach out to them via email. Put down their citizenship, put down their PAN, put down their Aadhaar number. Where you are not able to reach out to them in any way, then you can take government's help. And if say there have been certain interactions with the government, then using this data, government might be able to help you identify them. Put down their addresses as well. So very important these days to put the identification of all the parties and the modus operandi on how you can reach out to them. Okay. Then again, as part of the deed, one important point is custody of minor kids. Okay, this is a very, very important and an interesting point. So last year I was on a tour to US. I met a couple of lawyers over there. What they told me is that many Indians who are over there on H-1B visas, say engineers who would have moved over there for taking up studies and jobs, they make a very important mistake. What happens is that generally they plan their kid in while they are on the US soil, and if their kid is born while they are in the US, then the kid gets US citizenship. Okay, so the kid is a US citizen, but parents are not US citizen. Okay, in such a case, if say for example, because of any unfortunate event, both the parents pass away. Okay, so their grandparents would generally be based out of in India. Yeah, but the custody of the kid would not automatically go to the grandparents if a will has not been returned by such parents, because this particular kid is a US citizen. US has the responsibility of taking care of that citizen. So if a will is not returned, then automatic custody does not pass on to the grandparents or anyone close to the family who is not a US citizen. So if you have clients where the say the smallest of the kid is a US citizen, please tell them to write a will, and in the will you expressly mention that the custody of your kid should go to so and so person if something happens to you, so that if at an overnight way or an unfortunate event you pass away, then your kid does not go to the foster home in US and you don't have to fight for their custody. Because of the will, your kid's custody, who is a US citizen, will pass on to the grandparents. Yeah, a very, very important point. Please keep this in mind while planning this. Yeah, bequeathment of residuary assets, which is a last most point, that in the will you have to mention a point that all your residual assets should go to so and so person, so that your residual assets do not form part of any litigation. Then comes the first preference for payment of liabilities, taxation, executors responsibility. That's a standard point. I'll not touch upon that. Yeah. Okay. Now, moving to the next slide. I think my PPT has got stuck. Let me just try and reshare that. Yeah, now my PPT is here. Okay. Now we move on to the private family trust as a structure. So what I'll do is, now I think I only have about half an hour of speaking time. So let me all the basic introductory slides, I'll just skip them so that we can focus on the core aspects. So private family trust is an excellent tool for succession planning. You remember at the start we discussed about the emotional objectives and financial objectives. So will, to some extent, it will fulfill your emotional objectives, but the will does not help to fulfill your financial objectives because you continue to own the asset. Now, private family trust is a beautiful tool by which my all my emotional objectives as well as my financial objectives get fulfilled. Because if you plan your succession in the right way using a private family trust structure, then what happens is that both emotional as well as financial objectives get covered up in a good way, because private family trust can also help you on ring fencing front as well. Yeah. And another important tool for private family trust is the Indian Trust Act. We are blessed with a very good act, which is the Indian Trust Act 1882. So the Indian Trust Act is a globally recognized law where across major jurisdictions they are respecting the Trust Act as per India. So if you set up a private trust in India, then that will be globally respected for. Certain myths around a private family trust. Yeah, just so there are certain myths around a private family trust. What are those is, so I commonly hear is a private family trust has its own PAN. Okay. Now, since the private family trust has its own PAN, so they say that the private family trust is going to be so the private family trust has its own PAN. So the private family trust is actually an independent entity. Okay, that is not the case. Private family trust is not an independent entity. It is not a person. Okay, private family trust is being defined under Section 3 of the Indian Trust Act. Okay, how does Section 3 of the Indian Trust Act define it? Is it has been put up on the screen. Section 3 of the Indian Trust Act, it reads as a trust is an obligation annexed to the ownership of property arising out of a confidence that has been reposed in and accepted by the owner for the benefit of another or for the owner or another. Yeah. So a private family trust per se is not actually a person. What is a private family trust? It is actually an obligation. It is actually a confidence. So there is a settler who wants to settle a private family trust. Oh, my screen sharing is stopped. Yeah. So the Section 3 of the Indian Trust Act, it says that it is only an obligation and a confidence. What happens is that there is a settler who has certain assets with him. He wants to pass on the asset to the next generation. Okay. So what does the settler do? The settler states that my assets will be passed on to the beneficiaries, but during my lifetime, I don't want the assets to move to the beneficiaries right now because say the beneficiaries are not ready. Okay. So then what I do is if the beneficiaries are not ready per se, then let me hand it over to someone who can manage the assets for the benefit of my beneficiaries. And as and when my beneficiaries will be ready, at that point of time, this person will pass on the asset to the beneficiaries. So, when a trust is getting formed, what is happening is the settler is giving a responsibility. The settler looks for a trustee. He brings the trustee in front of me. He tells the trustee, are you ready to take up the responsibility of managing these assets for my beneficiaries? And the trustee would say, yes, I will take up this responsibility and I am giving you the trust. I am giving you the confidence that I will manage the assets for the benefit of the beneficiary. So it is exchange of the responsibility and confidence between two parties. So in layman terms, it is nothing but a contract. So even though the trust has its own PAN, still it is not regarded as a person. In fact, most of the laws like income tax, FEMA, General Clauses Act, no one defines trust as a person. So this is a very common myth. Please be aware of that trust is not a person. Okay. Legal landscape for trust, I think I'll skip. We have already discussed about it. Key constituents of trust. So the key constituents of trust are four people. First is the settler. Who is a settler? A settler is actually someone in whose mind the idea is taking birth. The idea is originating. That say he's a person who owns all the assets. He feels that yeah, now is the right point of time. I want to plan for my succession. I want my assets to move to the beneficiaries. But at this point of time, the beneficiaries for any reason are not ready. So what do I do is, so he says that let me settle a trust, let me find the right person who will take up the responsibility of managing the asset and let me part away with the asset. So the entire birth of the trust, entire birth of the idea of creation of a trust takes place in the mind of the settler. So settler is the first person. The Indian Trust Act refers to the settler as the author of the trust. Okay, so the idea of trust initiates in the mind of the settler. He, under the Indian Trust Act, is called as the author of the settler. What is the role of the settler? He has to identify three things. First, he has to identify the property that he wants to move to the trust. Then he has to identify all the beneficiaries, and he has to identify the trustee person. Okay. So that is the role of the settler. Then moving to the next important point is who is a beneficiary. Section 9 of the Indian Trust Act defines who can be a beneficiary, which says that every person, here they are using the word person. That means a person can either be an individual, he can also be a body corporate. So yes, it is right. If I want to settle a trust, it does not mean that my assets have to go only to a natural person. I can bequeath my assets also to a body corporate. Forget about the tax implications that we'll see at a later stage. But Indian Trust Act allows you. So say if I am a patriarch, I don't want to give anything to a natural person. I can give the entire wealth to a body corporate, be it LLP, company, charitable institution, to anyone. Okay. So a beneficiary as per the Indian Trust Act can include both individual as well as a body corporate. Okay. Now here it says that every person capable of holding property may be a beneficiary. Now we all know that there have been trust deeds where courts have also upheld that many a times unborn kids and even pets in the family have been made beneficiaries of the trust. How does that happen is, so the Indian Trust Act is a very beautiful law. It is more sort of like a guiding document. A lot of things under the Indian Trust Act gets overridden by your express statements as part of the trust deed. So if you want to mention unborn kids and pets, they can happen. Limited extent practicality possible. To the extent possible, please define all the beneficiaries. But yes, this is a possibility. You should refer to certain judgments that might help you plan that in the right way. Okay. I get a question whether the beneficiaries can be non-resident. Yes, sir. A beneficiary, both residents as well as non-residents, permitted under the Indian Trust Act. Next important person is the trustee. We talked about the settler, we talked about beneficiary. Now coming to the trustee. Trustee is the legal owner of the asset. He is not the beneficial owner. Many people consider trustee as the beneficial owner, but there is a Supreme Court ruling which settles this particular issue. It clearly states that trustee is only a legal owner and not a beneficial owner. Okay. Then there are two very important provisions of the Indian Trust Act. If say you want to put a non-resident person as a trustee, so there is section 60 and there is section 73 of the Indian Trust Act. It advises that a person who is domiciled abroad is not the right person to act as a trustee. Okay, so if by any chances you want to appoint a non-resident person as a trustee, if you will ask me, possibility, yes, you can do that by expressly writing certain clauses in the trust deed very carefully to be drafted by an expert only in such a situation. You can appoint a non-resident trustee, but in general cases, please understand that the Indian Trust Act advises against it. Indian Trust Act states that a person who is domiciled abroad is not a proper person to be appointed as a trustee. Okay. Then another important point in section 60 is if the trust property includes custody of money, then at least two trustees are required. This is a mandatory provision. So if you are settling money in a trust, you have to appoint at least two trustees. Yeah. This was about trustee. Then there is a concept of protector, but in the interest of time, I'll skip that. Not important for now. Types of trust. So there are the types of trust can be divided into three blocks. First is the manner of creation. Okay. If say there is an aura, but how the trust is taking birth defines the type of trust. So either there can be an oral trust where there is nothing in writing, only between the exchange of words. Indian Trust Act upholds this kind of trust also. Then there could be testamentary trust. Testamentary trust are cases where trust taking birth by way of action of will. So the person drafts the entire trust deed, but he says that this will not be formed today. He attaches the trust deed as an annexure to the will, And the will states that as and when this person will die, the assets will directly not go to the legal heirs, the assets will get settled in this trust. So on the day of your death, the trust gets automatically settled. That's a testamentary trust. And non-testamentary trust is the most common tool, which is that the trust takes birth today itself. In front of your eyes, you are drafting the trust deed and forming the trust. Then the powers of the settler also define the type of trust. We have a case study for this, an interesting case study which we'll be discussing in the next 2-3 minutes. If the power, if the settler states that I want to give the assets away, but I'm not confident enough, I want to retain a possibility that if, say, my planning of the trust is not working well, or during my lifetime I want to take back the asset, then he would retain a power with him that at any point of time in my life I'll take back the asset. So if I'm taking back the asset, it says that I have kept the power of revocation with me. Revocation means to just take back. I've kept the power of revocation with me, and such a trust is called as a revocable trust. If the settler says that no, if I'm settling the trust, the asset moves away from my side with absolutely no possibility of me taking it back, then it's an irrevocable trust. Okay. Then the third type of asset is based on the distribution powers that are in the hands of the trustee. If the trustee is left with a discretion that you decide in what proportion you would want to distribute assets to the beneficiaries, it would be a discretionary trust. But if the trustee states that in so and so proportion, in so and so manner, the assets should be distributed to the next generation, then it is called as a specific or a determinate trust. Yeah. So these are the three buckets. Now, one interesting discussion which we need to do around what is a revocable trust and an irrevocable trust, where many people go wrong. See, under section 78 of the Indian Trust Act, revocable trust is defined to mean that where the trust has been declared, I'll directly jump to the point. Under the Indian Trust Act, it says that if an express reservation has been kept with the author of the trust at the stage of settlement, only then it's a revocable trust. Meaning what? If I've written a trust deed and the settler has put in a clause that me being the settler, I retain the right to take back the asset either conditionally or unconditionally. If such a clause is formed part of the trust deed, only then, because it's an express clause, it will be treated as a revocable trust. Okay. But under the Income Tax Act, there is a deeming fiction attached to it. Under the Income Tax Act, this is a deemed concept which they have bought. What they state is, if as part of the trust deed, there is any provision where directly or indirectly there exists a possibility of retransfer of whole or any part of the income or asset back to the transferor, then the law deems it to be revocable in nature. Okay, let's not spend time in deliberating on the language. I have a good case study to explain that. Let me directly move to the case study. So this is case study 1. Here, what we have is there is a scenario which we are currently looking at. What is there in the scenario is there is a ancestral home. Say for example, there is a big family staying in an ancestral home. So there is a legacy ancestral house which has been running in the family since many generations. Today the property has significant financial value and it has deep sentimental value also. Okay. But what is the situation is, so say there are 50 family members staying in one single house, but today it is owned by only one family member. Okay. So this particular member feels here today we are 50 family members staying in this one house, but on the agreement, only my name is present. This I feel is not the right way. Every one of us should own the asset in equal, should own the asset. Everyone should be the beneficial owner of the asset. So what this person does is, what if I settle a private and a discretionary trust and I settle this particular house in the trust? I name all 50 family members as the beneficiaries of the trust. So will my objective get achieved? Yes, it would get achieved. Why? Because all the family members are beneficiaries over here and the asset now lies with the trust. I am making this as an irrevocable trust. I am not reserving any right
to take back the asset because I don't want the asset. The relationships in the family are very crystal clear. I don't want to retain any revocability right, because if I retain that right, some family members might not like it. Okay, so I am just letting go of the asset, settling it in a trust where entire family is made a beneficiary, and this is an irrevocable trust with no possibility of the asset coming back to me. Okay, so he settles this trust. Now he is under one dilemma. What he feels is, yeah, when I'm listing down the beneficiaries, I am also one of the family member who is staying in the house. So I also have to be named as a beneficiary in the house. Everyone says, yes, you also have to be named as a beneficiary in the house. So alongside the 50 family members, he is also named as one of the beneficiary. Now, who is going to own what percentage? They are like, nahi yaar, let us keep this discretionary in nature, because we don't know today which family member is going to behave in what particular way. So why do I create any specific trust? If there are certain members in future might go away from the family, so we'll remove them from the trust. If there are new members who will get added, we'll add them to the trust. So let's keep it at discretion. Let us not specify the beneficial interest. So they keep it as a discretionary trust. Okay, and he is also one of the beneficiary in the trust. Now, what is the dilemma over here is, he has not kept any express revocation clause in the trust deed. Why? Because he always had the thinking that I do not want the asset to come back to me. So in his mindset, he has settled an irrevocable trust. Now, let us read the definition again and see how this is getting classified. Okay. Under the Indian Trust Act, the condition was that there has to be an express reservation in the hands of the settler that the asset should move back to him. Is there an express reservation in our example? The answer is no. He has not kept any express reservation because he is very clear in his mind, asset should never come back to me. So, under the Indian Trust Act, this gets classified as a revocable trust. Okay. Now come to the definition under the Income Tax Act, which is under section 98 of the new act. Okay, exactly same as per the old act. Let us read it together. A transfer, which is a settlement, shall be deemed to be revocable in nature if it contains any provision for direct or indirect retransfer of the whole or any part of the income or assets to the transferor. Now, what does indirect retransfer mean? See, he is also one of the beneficiary in the trust. The trust has been designed in a discretionary way. In a discretionary way, there is a possibility that maybe all 51 family members will get equal right, or there is a possibility that the trustee can exercise entire discretion only in favor of one member and pass on the entire asset to that person. Is it possible? Absolutely, it is possible. The law allows that. So now in our case, the settler himself became one of the beneficiary. So there is a possibility, which means there is a provision which contains that directly or indirectly. If in future the trustee exercises his entire discretion in favor of only one individual, which is the settler himself, then there is a possibility that the entire asset can move back to the settler. So here when I see the term indirect retransfer of the whole or any part of the asset back to the transferor. So because of the provision that I have named myself as one of the beneficiary as well, there actually is a possibility that the asset can move back to me and I fall within the clutches of this particular provision. Right? A very common situation. This trust setup you'll come across in lots and lots of cases. So now what happens in this particular case is, the result is, under the Indian Trust Act, I am irrevocable. But under the Income Tax Act, I become revocable in nature. A very, very, a situation which many people fail to understand and leads to a wrong setup. And it leads to a revocable trust, because once it's a revocable trust, then there are certain treatment under the Income Tax Act like clubbing of income and all those provisions get triggered. So in a very, very niche way, you have to design the trust in a very systematic way. So I wanted to keep this case study, just to highlight that between the types of trust, the drafting of the trust deed has to be extremely crystal clear and razor sharp. Only if your trust deed is drafted in the best possible way, then the classification of the trust will happen in the right way. Otherwise, it can go for a toss, because if the trust is drafted in a poor way, then you would be under the presumption that my trust is so and so. My trust is to be classified in so and so way, but actually speaking, on paper, the classification leads to an altogether different result. Yeah. So I wanted to, I'd kept this particular part for that. Now, covering part of trust deed and letter of wishes, I think this is fine. We can skip that. I'll cover the tax framework first, because that would be quite important for a lot of our participants. So let me cover a simple case study that will give you the main gist of the entire tax implication per se. So this case study has very simple facts. We will traverse through the entire life cycle of the trust. And in each stage, whatever are the key tax implications, we'll study over here. So let me just run through the case study. I think we are at 6:38 right now. I was supposed to stop at 6:45, but I'll take 5 minutes more. We'll end by around 6:50, and then we will take up the take up the Q&A part. Yeah. First is settler, the purchase date. What over here we are doing is there is a person who purchased certain shares on 1st April 2019. At that stage, the cost of the shares was 1 lakh. Okay. He was holding the shares in his own hands from 2019 right up to 2024. Okay. Now, in April 2024, a desire rose in his mind, where what he felt is, I don't want to hold these shares for my personal benefit. I want to pass it on to the beneficiaries, but the beneficiaries are not yet ready. So I want to settle a trust, and I am settling an irrevocable and a discretionary trust. Okay. So on 1st April 2024, I am settling a trust where I am moving the asset to the trust. But on 1 April 2024, now the fair market value of the asset is 1,50,000. I purchased this for 1 lakh, and now the fair market value is 1,50,000. From 1 April 2024, for the next 4 years, the trustees held the asset for the benefit of the beneficiaries. And now on 1 April 2028, the trustees are making the distribution and transferring the shares to the beneficiary, because the trustees feel that now the beneficiaries are ready. So we want to exercise that discretion, pass on the asset to the beneficiary, and shut down the trust. And finally, on 30th August 2028, the beneficiaries are selling the asset to the third party. Right? This is the entire life cycle of the trust. The person bought an asset. A desire arose for succession planning, so he settled the asset in the trust. The trustee managed the asset for a certain period of time. The asset got distributed to the beneficiaries, and finally, the beneficiaries sold it to the third party. So let us see the implication at each stage. First stage arises is the stage of settlement. So at the stage of settlement, the two parties that are involved is the settler and the trustee. Why? Because the settler is letting go of the asset and the trustee is receiving the asset. Okay. So in the hands of the settler, whether there are any tax implications. So first, if I were to talk on the first principle basis, settlement itself is actually not a taxable event. Okay. In the commentary by the great Kanga and Palkiwala, they have clearly mentioned that liability can only arise when there are gains. At the stage of settlement, the settler is not gaining anything. So there should have never been the question of taxability. But still, the law had introduced section 47(3), subsection 3, which is transfers not regarded as, certain transactions not regarded as transfers, where certain transfers were given exemption from capital gain clutches. And in 47(3), a special exemption was given for any kind of settlement happening in the trust. So the year in which this was introduced, Kanga and Palkiwala made a very landmark statement stating that here the government have actually given an exemption where none was needed. So on the first principle basis, at the stage of settlement, in the hands of settler, you never have test capital gains. But still, if you were to still test capital gains, then under section 47(3) and under the new law as per section 70 subsection 1, you will get an exemption. Coming in the hands of the recipient, we have to test something like, say, section 56(2)(10). But and again, on first principles, whether 56(2)(10) applies, the correct answer is it should not apply. Why it should not apply is, see, let us bear in mind what is happening at the stage of settlement. At the stage of settlement, the trustee is giving confidence to the settler. Okay, that yes, I am ready to manage the property for the benefit of the beneficiaries, and the settler is leaving his trust on the trustee. Okay, 56(2)(10 applies only when I am receiving an asset for inadequate consideration or for no consideration. Can I say that the trustee received the asset for inadequate consideration or for no consideration? The answer is no. Okay, consideration has been defined under the Indian Contracts Act, and the Indian Contract Act states that consideration can be in money, in kind, or in any other form. So, in this particular case, when the trustee is passing on the confidence to the settler, when he is accepting the responsibility, this particular software aspect is sufficient consideration for the settlement. So actually 56(2)(10 also should not apply. But still, if someone was to disregard the first principles, then also you would get exemption available, because there is an exception under clause 10, which says that if the settlement is happening for a family trust where the beneficiaries are only my relatives, then there is no 56(2)(10 act. So at the stage of settlement, if you are drafting the deed in the right way and it's the right structure, then there would be a no tax implication on this particular stage. It will be a pass through. Okay. Now coming to the life cycle of the trust, where the trustee is owning the asset. Now this is a discretionary trust, and say the trustee earned dividend income. So as per old section 164, there was taxability at maximum marginal rate. Okay. Now many a times there are someone asked me a question that what if the trust would have earned capital gains? In capital gains, say it's a long-term capital gain, would the tax rate be 12.5% or it will still be the maximum marginal rate? So there is a very good ruling in case of Jamshedji Tata Trust, which clearly states that MMR in case of special rate of income will be restricted to the special rates prescribed under the restrictive section. So they say that the MMR, as per its own definition, cannot override the rates which are given under the specific sections. So if there are special sections levying certain rates, those rates itself become the maximum marginal rate for that class of income. So for capital gains, using this ruling, your MMR would still be 12.5%. Then last year, there was an interesting judgment by the special bench of Mumbai Tribunal in the case of Aradhya Jain, which says that even the surcharge will not always be the highest rate. Surcharge also has to be qua the income that has been earned by the trustee. So say the trustee has only earned, say, 20 lakh rupees, then there would absolutely be no surcharge, because the minimum threshold for the surcharge to trigger is 50 lakh rupees. Yeah. Then there is a possibility under the discretionary trust also to pay tax in the hands of the beneficiary. The answer is, if there has been an assessment in the hands of the trustee, if the trustees in the representative capacity have already paid the tax, then there would be no tax liability in the hands of the beneficiary. Plus, if there is a Supreme Court ruling in the case of Kamalini Khattab, which says that if during the year the trustee earned the income, though it's a discretionary trust, but in that same year, only in relation to the current income, the trustee distributed the income to the beneficiaries. Then, using the ruling of Kamalini Khattab, the beneficiaries can offer that income to tax in their own hands. In that particular case, it would be at actual rates and no MMR would be charged. Yeah. So, in the life cycle of the trust, the trustee pays the tax at MMR. If the trustee makes the distribution to the beneficiaries, beneficiaries have the option to pay tax in their own hands, citing the ruling of Kamalini Khattab. Okay. Now, moving to the stage of distribution, where the asset has now been distributed to the beneficiary. Is it again a taxable event? The answer is no. Here, luckily, the tax department also has never taken a negative position. They are in sync over here. The distribution in itself is not a taxable event. Whatever was the taxability, we have already evaluated at the stage of the settlement, because the real transfer happened at that point of time. Now, only the beneficiaries are realizing something which was settled for them. Yeah. So that would happen. Post distribution, dividend would be taxable in the hands of the beneficiary. That's obvious, because now the beneficiary is holding the asset. They would pay tax on the income that is earned thereon. Now the beneficiary has distributed the asset. So now is the real time when a sale price of 2,10,000 has been received, because the beneficiaries have sold the asset to a third party. right? So here the question is, what will be the taxability in the hands of the beneficiary? Would there be capital gain? Yes, because now there is no trust structure. Beneficiary was holding the asset in his individual capacity. He transferred that. So there is capital gains. Now the question arises, what is going to be the cost in the hands of the beneficiary? Would it be the date when the distribution happened, which is April 2028 and 1,75,000? Would it be when the trust received the asset, or would it be in the hands of the original settler? So section 49(1)(3) comes in handy for us, and it clearly states that in this case of settlement to a trust, it is going to be the cost of the previous owner. So in our example, since all throughout it has been a tax-free transfer, so the purchase price in the hands of the settler would continue to be the cost price in the hands of the beneficiary when they are selling the asset. Yeah. Then the next question arises is, what is going to be the period of holding? Again, section 242A clearly states that even the the entire holding period of the previous owner will be given to the beneficiary. So even though the beneficiary is received on 1 April 28 and within a couple of months he sold on 30th August 2028, still it will not be a short-term asset. It would be treated as a long-term asset, and the resultant gains would be long-term capital gains. Yeah. So this is how the entire life cycle of the trust works and how the taxability arises at its stage. Sorry, I had to rush a bit because of the timing issue per se. Fell short of the time, but I think I've covered fairly what I wanted to discuss and cover as part of the part. So yeah, I think since we are at 6:50, so maybe I'll just take a break for a minute, and then Yashvi, should we go ahead with the Q&A?
Yes. Yeah. So I'll read out the questions to you.
Yeah, that would be great. Yeah.
Okay. The first one is, can you explain ring fencing in detail?
Yeah, sure. Can you all see this notepad?
Yes,
Something.
it's there.
So see, what happens is, if there is Mr. A, okay, Mr. A is owning assets which are, say, 100 crores worth of, say, the market value of the assets is 100 crores. Okay. Now, say let us take an example. What does Mr. A do? Say, for example, Mr. A, maybe say he is in a business of tours and travels. Okay. He regularly takes customers on various tours and travels. Unfortunately, if say in one of his tour, because of certain mishappening or because of his mistake, one of his customer passes away. Okay. And now the family of this customer is filing a case against Mr. A per se. Okay. And say, for example, this is not a case where Mr. A is going to be imprisoned. Let us only consider the monetary liabilities. The family has filed a case against Mr. A. And in this particular case, a settlement arose and a settlement amount was decided to be, say, 50 crores. Now, if since the ruling has been passed in against Mr. A, so Mr. A will have to pay 50 crores out of his asset of 100 crores, 100 crores, and that will move away. Now, let us take the same example. Move on. Mr. A asset wealth was 100 crores, but during his lifetime, Mr. A had created a trust, a private trust, which was irrevocable in nature. Okay. And in this trust, maybe out of this 100 crores, he had settled, say, 75 crores over here. Okay. Now, Mr. A, at this point of time, what is the asset that Mr. A is owning in his personal name? It would only be 25 crores, which is 100 crore minus the 75 crore which has already been settled. And same thing happened now, and a litigation came on Mr. A, and now Mr. A was supposed to pay 50 crores as the liability, but Mr. A is only owning assets worth 25 crores. So the court can only demand this 25 crores to move to the plaintiff, whosoever has filed the case, the assets which are parked in the trust will be ring fenced. That cannot be attached to any liability that is arising now in the hands of Mr. Way, subject to conditions. Obviously, if the trust would have been settled while something of this sort of mishap happened, or someone can prove that this trust was settled in a fraudulent way only to ensure that this liability would not get paid off, all those situations are separate. But in a genuine case where such a situation arises, you had a trust in place where assets were passed on, then no one can draw down this 75 crore worth of assets for any liability that is pending in your name. Whatever you are owning in your only name, only that will get addressed. So by ring fencing, what I mean is whatever assets you move to the trust, that get ring fenced, that get protected from the liability that is going to arise in your individual name. Yeah.
Okay. The next is, can you please explain what exactly probate means?
Sure.
Also,
the-
ring fencing is not available in will, right?
No,
Ring-
it is not available in bill.
Okay.
See, ring fencing, what happens is that whenever a liability comes on you, on the date of the liability, whatever asset is in your personal name, that cannot be ring fenced. Okay. In a will, everything is in your personal name. Only when you die, things are moving to the next generation. So, in a will, ring fencing is zero. In a private trust, also only under irrevocable structure, you get complete ring fencing. Yeah. Now, moving to the question of probate, let us again take an example. Say, for example, Mr. A has an immovable property in Mumbai. He has a lot of financial securities. He has written a will and he has, say, three legal heirs, wife and two kids. He has distributed all the assets to them in equal proportion. Now, Mr. A passes away. Okay. So, his immovable property and all the assets have to move to the next generation. So the next generation will take the will copy and move to each of the asset places, say immovable property. They will go to the housing society, the committee of the housing society, give the will copy to the society and tell them that we are the legal heirs, transfer the property to us. So the housing society will not do that. Okay. What they will say that you first get the will probated. For the probate, what does it mean is that the document that you are submitting to mill, is this will the genuine one? The housing society has no way how they can decide that. So they would say that we are not going to distribute the asset to the legal heir based on this document. You take the document to the court. Okay. So now the executor of this particular will take the will copy, approach the right court, will present the will to the court. Now the court will take 6 to 9 months time. They will put up lot of NOCs, lot of process will be done in news media, newspapers. If no objection comes and the court is satisfied that the document which is presented before us is the final document, final will of so and so person, then the court will keep the copy of that particular will. Original retains with the court. The court will take a Xerox copy, attach the letter of administration to that, and it would state that the document which is attached as an annexure is hereby the last and final will of the person whose will has come before me. And based on this, the assets can move to the next generation. So the probate is granting blessing that this particular will is final, it is genuine, and this is the last will. Now, this probate copy you can submit everywhere, and no one is going to question that, and they will transfer the assets to the legal heir. So this is the process of probate.
Okay.
Yeah.
So the next question is, can a beneficiary and trustee be same?
Yes, they can be same. So there is a very good ruling of Gujarat High Court in the case of Bhavna Nanavati. You can take note of that. Bhavna Nanavati, it's a Gujarat High Court ruling at the time of gift tax. That ruling states that one person can hold at least two positions. Okay. So settler and trustee can also be same. Trustee and beneficiary can also be same. But generally speaking, beneficiaries do not become the trustee. Why? Because in a private trust setup, you would not want to do that, because if you are setting it up in a discretionary way, then if the beneficiary is only the trustee, then a lot of biasness can come into play. But technically speaking, yes, beneficiary can also be one of the trustee. Yes.
Okay. The next is, can settler become a trustee? You answered it. Yes. There are series of questions. Are letters of wishes mandatory on settler? What are the remedies if that letter is not followed?
Yeah, so I had a slide for that. I'll just briefly tell that. Under the Indian context, Indian Trust Act doesn't talk about letter of wishes. So whether there is a legal support available to that, the answer is no. But in courts, there have been precedences where the letters of wishes have been appreciated. Now, what is a letter of wish? Okay, letter of wish is a document which cannot direct the trustee or cannot override any of the terms of the trust deed. Okay, many people what they feel is that in the trust deed we will keep minimum clauses, we will write everything in the letter of wishes. That is a wrong conception. Letter of wishes is more sort of like an emotional document where you write down all the guidance for the trustee, that as and when in future if the settler is not around, he is not alive, and the trustee is now in the position of making a distribution and he needs certain guidance, okay, what would the settler would have felt or desired at this point of time. Those kind of emotional things are captured in a letter of wishes. It is not an overriding document. It cannot override or direct the trustee to do anything. It is only a guiding document with no legal validity, but highly appreciated, and it has a lot of practical importance. Yeah.
Okay, it is then a similar to will. Can it be changed? How can a trust deed be revised with immediate effect, and how much time it takes to get that amended?
Trust deed can be amended by passing a supplemental trust deed per se. It will again have to be executed by the settler and all the trustees. Because see, the trust deed is a contract between the settler and the trustee. So settler and the trustee, if both of them are alive, then they can execute a trust deed and change any kind of terms that were laid therein by executing a alternate trust deed. It can only have prospective effect, can be made immediately. Today, if you draft the trust deed, from today it becomes effective. Now
Okay.
come to a situation where the settler is not alive and still you want to change the trust deed. So there is a requisite section under the Indian Trust Act that says that if the trustee is changing any clause of the trust deed, which was the settler's intention, then he can change that only by taking a unanimous approval from all the beneficiaries. So by taking a unanimous approval from the beneficiaries, the trustee post the settler's death can also amend the trust deed.
Okay. Can an owner keep some assets out of family trust scope?
Yeah,
Yeah.
absolutely. Yeah.
What is process and timeline to change the executor or settler? Who has the right to do it and who can be appointed as trustees? If is there a minimum number of trustees to be appointed?
No, I think all the questions are different. Let us go one by one. Yeah.
Oh,
So the first one.
uh, okay. What is the process and timeline to change the executor or settler?
Both are actually different things. Executor is for a will, settler is for the trust. Executor of the will you can change at any point of time by drafting a new will. Immediately can be done. Only you have to execute a new will. Just write that so and so person will now be the executor. It's very simple. Then the question was how to change a settler. Settler can never be changed. See, settler was the one who originated the idea of the trust. So settler is someone who can never be changed.
Even an unregistered will has the same authenticity in the court. Can a
Yes.
will override inherited property or just self-acquired property?
Mm, Confusing question.
Yeah.
Can you repeat that again?
Even an unregistered will has the same authenticity in the court.
Yes.
Yeah.
Registration of will under the Registration Act is an optional document. It is not mandatory.
Okay. Can a will override inherited property or just self-acquired property?
Both. In my will, I can mention self-acquired property as well as inherited properties as well. In fact, I also mentioned a point that even undivided co-parcenary interest in an HUF can also be bequeathed. So will has a lot of powers.
Okay. Then can an estate duty be awarded if private trust is formed? Yes.
Yes.
If
If it is designed in the right way, it has to be irrevocable and discretionary. Obviously, I mean, tax planning of the trust is altogether a different subject because a lot of minuteness and lot of attention has to go in the designing of the trust only to achieve those objectives.
Yes. Income tax department is processing the returns of trust by adding 37% surcharge despite low income. What should be done?
That's right. So that's a practical difficulty. Change the taxes manually while filing the return once you receive 143.1, my practical suggestion is request for the jurisdiction to be transferred from CPC to the AO. Go and meet the AO, submit the requisite case laws. The AO will allow you the right taxes.
Okay. If advance tax is paid by the trustees of the discretionary trust on the current year income of trust, whether assessment can be made in the hands of beneficiary on the distribution of this income?
No. So if the trustees have already paid the tax and if the trustees have opted to get assessed in the trustees' hands itself, then the officer cannot start another assessment in the hands of the beneficiary. If at all the officer goes ahead and does the assessment in the hands of the beneficiaries, he will have to factor in this particular advance tax liability as well.
Can a Hindu PIO holding citizenship of Hong Kong holding assets in India settle a trust?
So cross-border trust is actually a very different topic. It has a lot of FEMA issues part of that. I usually speak on that topic where only FEMA is there for 2-3 hours. So let's not mix that with today's topic. I mean, it
Okay.
will not be in the right way. And I'll also not be able to give answer in the next 30 seconds.
Okay. Will stamp duty be applicable for settlement of assets into trust? Is registration of trust deed mandatory?
First, stamp duty, definitely it's applicable because there is a transfer of asset and trust deed is an instrument. So stamp duty is definitely applicable. What is the second question? Part of that?
Is registration of trust deed mandatory?
If there is an immovable property that is getting settled as part of the trust deed, then as per Registration Act, it is mandatory to get the trust deed registered. But if you are only settling movable assets, then it's an optional thing.
Okay. Is tax payable by the trustee himself or he is just manager and pays out of trust?
He is not a manager, he is a representative assessee. So he doesn't pay tax in his individual capacity, he pays tax only in his representative capacity. So if say I am a chartered accountant, I would have my professional income as part of my practice. If I am acting as a trustee for a trust and if I have to pay any tax, nothing to link with my personal assets, I will be paying tax out of the trust corpus only.
Okay. So, if I transfer my property to a trust, would stamp duty be required to be paid?
I think, yeah, we have covered that.
Yes, we covered. What is the stamp duty for creating a trust?
It would depend qua the asset, it would depend qua the state, it would depend qua where each of the parties are stated. So for each asset, it is different. Like say, for example, for immovable property, the law states that the state where the property is situated, that gets the right to collect stamp duty. So as per the rates in force in that state. For financial securities, it states that where the recipient is a resident of. So in this case, the trustees and beneficiaries, the state in which they are located, that state collects the stamp duty. For other movable assets also, you will have to see where is the place where the instrument is getting executed.
Okay. I think in case of Hindu family, the inheritance property owned by the father will go to the son or son's HUF after father's demise. Can you give legal reference for it?
No, sorry, I did not get the question.
Yeah. In case of HUF, Hindu family, okay, in case of Hindu family, the inherited property owned by the father will go to the son or son's HUF after father's demise. Can you give legal reference for it?
No, so I don't think so. Under the Hindu succession law, any property directly moves to the HUF. The property has to be contributed to the HUF. It is not getting contributed to the HUF, then the property keeps on moving as per the class of S which are stated under the Hindu Succession Act.
If husband and wife have made different wills with provision for transfer of some assets to each other, if one dies earlier, what if both die together?
So you always have to keep a waterfall mechanism. So generally, whenever you are drafting a will, you are bequeathing any asset to any beneficiary. Always consider the possibility that what if that particular beneficiary dies before you, predeceases before you, or both of you die at the same way. So you always have to keep a waterfall mechanism, which we drafted as part of the will. So no asset should go into a limbo. Based on that waterfall, you will have a residual person finally who will receive the asset.
Okay, I think we're done with the questions. Also, major questions were like, will you share this PPT? Uh,
Yeah,
to
I mean, I am
maybe
happy to share it with the committee if you all feel you are
yeah.
comfortable with it. Yeah, sure.
Okay, I'll Okay.
I'll share it with so my PPT are going to be having a lot of slides which I actually wanted to cover, but because of time I couldn't cover. I'll share the entire PPT with you guys, maybe if that's beneficial.
Okay. I think we're done with. Okay, last question someone has put in. See if you can touch up on structuring of family trust as well. Parent trust and separate trust for each beneficiary. How does this kind of structure help?
Again, so structuring would take a lot of time. We are already at 7:10. I might not be able to answer that. So it would actually, we have to understand the facts of the family and then design the entire trust structure. And in my practical experience, or in most of the cases, discussion with the family goes on for at least couple of hours to understand the entire facts. And only then the trust structure gets designed. Because there cannot be one single structure for each family. And these days, I mean, rarely there are families who would not have a cross-border exposure. So when the FEMA angle gets involved over here, it completely changes the ball game. So structuring of a trust is a very different topic. So I will not be able to discuss now, but if you can drop me an email or a WhatsApp, I'll be happy to discuss in an offline way. Yeah.
Okay, I think we'll conclude this session. Thank you so much, sir, for your insightful learnings, and it really helped and simplified everything. This complex topic of wills and trusts. And thank you to the audience for being patient. Thank you, everyone.
Thanks a lot.
I think we can end the session.
Sure. Yashvi, just in case if you receive any feedbacks from the participants, please do pass it on to me if there are any constructive feedbacks.
Sure. Sure. I think everyone's very happy. They are writing thank you. I hope you can see the comment section on the
Oh,
webinar
yeah,
chat.
I can see that. Oh, wow.
Yes.
Great.
It's someone's written best session on trust. Very well explained. Thank you. Yeah, and indeed, it was an excellent session. Honestly, it really simplified everything.
Super.
I wish there was some more time. Then in detail, we would have been able to
Yeah.
go
No,
through
definitely.
with
If you
it.
want a next session again of this, please let me know where we can focus on cross-border and structuring aspects also, because I think
Sure.
there are a lot of questions around that
Yes.
we couldn't answer. Cross-border trust is also a very interesting topic. We have a lot of case studies on that. We
Sure.
can definitely do that.
I'll pass that on to Chairman Sir that to keep this. It should be 4 hour session, someone has written.
I will also have my limitation. We
Yeah.
can maybe keep 2 hours on 2 days, but one
Yes.
single day maybe talking 4 hours might be a lot.
Yeah. Yes.
Sure.
Yeah. I'll ask Sir for the PPT one. So yeah.
Perfect.
Okay.
Okay.
Sir.
Yeah. Thanks a
Thank
lot.
you. Thank
Bye
you.
bye. Have a nice day, everyone.
Yes.
Bye bye.
Yes, sir.
Can I also exit the session, Yashvina?
Yes, sir.
Okay.
We are
Great.
closing it.
Okay,
Yes.
great. Thanks.